Hey, it's Candice Quinn from Contract Hack. So last night, my 8-year-old decided to negotiate a later bedtime with me. He convinced me to let him stay up past his bedtime, eat ice cream, and not brush his teeth. And I'm a lawyer. I negotiate contracts for a living. How did my 8-year-old do this? Well, the worst part is I taught him everything he knows. So he did learn from the best, but still, how did he get one over on me? Well, I'm going to tell you. So he used some pretty sweet tactics against me, and I'm going to explain those tactics to you and how you can overcome them. First, let me set the scene. It is 8 p.m. on a Tuesday night. Bedtime is 8:30, which has always been a non-negotiable. My son comes in the kitchen where I'm cleaning up from dinner, and he says, "Mom, I want to talk to you about something important." All right, I should have seen it coming, but I was tired. I'd worked all day. I'd cooked dinner. I'm cleaning up. He sits down at the counter, like very formal, very serious. This is what he says. "I've been thinking about my bedtime, and I think we need to renegotiate our agreement." Our agreement. Our agreement. Those were his actual words, as if we agreed on a bedtime, instead of, me telling him his bedtime. I could have laughed, but I remembered, well, I'm the one who uses the attorney language around him. I talk to him like he's an adult, so now he's talking to me like an adult. Okay, whew. So I decided to sit down and talk with him. Basically, I was just really curious as to where this was going to go. That's when he absolutely dismantled me. So tactic number 1, anchoring. The first thing he does, before I can even say anything, is he tells me he wants his new bedtime to be 10:30. 10:30 for an 8-year-old. Now, I know what you're thinking. That's insane, and it is. But here's what he did that was brilliant. He started with an anchor that was so egregious that anything else would have seemed better. In negotiation, anchoring is when you set the initial reference point that basically anchors the entire conversation around that time. And research shows that even when we know an anchor is outrageous, it still serves as the anchor and we circle around it. By my son throwing out 10:30, it made 9:30 seem like reasonable, which then made 9 seem like a very reasonable compromise. His real goal was always probably 9 o'clock. So he just shot higher and was hoping to settle at what his goal really was. And we see this in contracts all the time. Vendors send us a contract with a really unreasonable limitation of liability, and when we suggest something a little bit more reasonable, they jump all over it. Of course they do, because they never really wanted the highest one, but that you felt was better than the unreasonable number they chucked at you first. So what do you do when you get thrown an anchor? Well, first, recognize it for what it is. It's probably designed to shift your perception of what is reasonable. Then you're going to reset the anchor, which means bring it to something that is actually a reasonable starting point instead of the outrageous one that was thrown at you. You can do that by saying, well, actually market rate is, or industry standard is, and you never want to negotiate against yourself. So if you counter with 9 p.m. to the 10:30, don't go back to 9:30 if there's nothing else thrown from the other side. Just because someone throws an anchor doesn't mean that you need to meet them halfway. Never let opposing counsel's anchor work on you. Tactic number 2, creating false urgency. So after my son throws out 10:30 and I try to push back, I'm explaining why 8:30 works, why it's a perfectly reasonable bedtime for an 8-year-old. But then he hits me with, well, if we don't figure this out tonight, I'm going to be too tired to go to school tomorrow. I won't be able to sleep because I'll be stressed about this conversation. He created urgency where none existed. Like, this is a classic move from opposing counsel. We need this signed by the end of the day or the deal falls apart, or these terms expire at the end of the year or the end of the quarter. Gotta sign now, now, now. Sometimes urgency is real, but let's face it, most of the time it's manufactured and isn't real at all. When someone creates artificial urgency, they're trying to push you past your decision-making threshold, make you skip the due diligence, force you to accept terms you'd normally push back on, and create fear of loss. So here's how to handle it. You need to test the urgency. So ask, what happens specifically if we don't meet this deadline? Have them explain the actual consequences. Then you need to set your own deadlines. So say, I need 3 business days to actually review this. If that doesn't work for your timeline, that's okay, but I'm not comfortable moving forward. You can also just call it out. Say, hey, it seems like we might be manufacturing this deadline here. What's the real reason we need to get this closed? With my son, I should have said, we can have this conversation over the weekend when we both have more time to think about it. Instead, I stayed in the negotiation, which leads me to tactic number 3, the package deal. At this point, I'm starting to cave on maybe changing his bedtime to 8:45 on weekends. That's when he goes for the kill. Okay, so if I'm gonna go to bed later, I'm gonna need another snack because I'm gonna be hungry before I go to sleep. And also, the extra time should be my free time. So I'm gonna skip all my homework and not brush my teeth and just go hang out. He bundled 3 separate requests into one: later bedtime, the snack, and skipping brushing his teeth. He made it seem like they were all connected when in actuality, they're not connected at all. This is the package deal tactic. You see this in contracts all the time. It's when someone says, we'll give you the indemnification if you give us the limitation of liability, the IP clause, and the warranty clause. They've bundled together 3 things that really don't have any relation to each other just to give up one thing. They want you to accept the package without evaluating the consequences of each item individually. And it's pretty powerful psychology because once you've agreed to one of the things, it seems easier to agree to the other 2. But here's how you need to handle it. Unbundle everything. Don't relate 3 things that have no relation. So first you want to talk about bedtime, then you want to talk about the snack, and then you want to talk about the teeth brushing. You need to give a value to each item. What is each item worth to you? Okay, he has another snack. That's not a big deal, as long as it's something good and healthy. But the not brushing the teeth, no, we're definitely brushing our teeth before bed. That's a no-brainer. So we're not gonna touch that one. Instead of letting him bundle it, what I should have said is, hey, we're only talking about bedtime right now. We'll talk about those other 2 things another time. They are not related to bedtime. But I didn't say that, and as a result, I ended up agreeing. I agreed to a 9 o'clock bedtime on weekends, a small snack, and teeth brushing skip on weekends. What am I doing? Tactic number 4, the trial close. Here's where it gets better. After we agree to all those things I just said, the 9 o'clock bedtime on weekends, the snack, the no teeth brushing on weekends, he says, well, if I do good with this on the weekends, we're going to try it on the weekdays too. This is genius. It feels low risk to the other party. Once the trial starts on the weekends and it goes well, then he's going to push for it to go to the weekdays because why not? It's become status quo. And once something is status quo, people hate changing it. You see this in contracts as pilot programs or proofs of concept. Once you get a customer hooked, then they're going to keep buying your product. And once they're using your product under the trial terms, well, they're going to be stuck with the trial terms for the longevity of the deal. Even if you've agreed to revisit, no one's going to revisit those terms. It's just too much work. But here's how to protect yourself in a real situation. Make sure those trial terms are definitely trial. Make them have an expiration date where a new set of terms has to be negotiated. You also want to set clear evaluation criteria. What makes the trial successful? What makes it unsuccessful? That way, the parties can argue about actual tangible facts. You also want to set up a calendar task to actually complete this review and not just let the status quo continue. You also need to prepare for the status quo bias. People are going to say, well, we're doing it this way. It's working. Well, could it be working better a different way? Let's talk about that. My son understood something that takes most lawyers years to figure out. Getting to yes on a trial basis is basically getting to yes forever. So here's what happened after our trial. Well, it's been 4 months and his bedtime is 9 o'clock every night now. Sometimes it's even later. He also gets another snack and he may or may not skip brushing his teeth some nights. And I just kind of have to deal with that one. The point is, I got negotiated into a position I didn't want to be in, all because I underestimated my opponent. He wasn't smarter than me. His arguments weren't better than me. I just thought I was going to win over him. He understood the mechanics of negotiation in that moment better than I thought he did. I stopped paying attention and he steamrolled me. This is what happens in practice all the time. An opposing counsel doesn't have to be smarter than you, more educated than you, more experienced than you to outmaneuver you. Don't fall asleep at the wheel or you will find yourself outmaneuvered. 1, know these tactics that I just shared with you. And 2, know how to get out of the tactics. What do you do if this tactic is thrown at you? How do you get out of it? 3, know how to separate the positions from the tactics. The client, they have real positions. The opposing counsel, they're just using tactics. So understand the real positions, and then you can find a compromise that will work for everyone. 4, you also need to set boundaries on the process. It's okay if you don't want false urgency. It's okay if you don't want anchoring. You need to set your boundaries and figure out how to negotiate within your boundaries. 5, teach this stuff anyway. Yeah, my son used it against me, but he's going to use this stuff for the rest of his life, and it is going to take him so many places because he has the ability to advocate for himself effectively and efficiently. I'd rather raise a kid who can negotiate than one who's afraid to stand up for themselves. The same goes for you. When you're negotiating against opposing counsel, don't be afraid to stand up for yourself. Use the tactics my son used against opposing counsel and know how to throw them back in their face. It will take you so far. If this video helped you see negotiations differently, go ahead and hit subscribe. And if you'd like to chat with me about how you can level up your career, go ahead and schedule a free call with me. The link is in the pinned comment and the description below. Bye for now, hackers.